Good afternoon, everyone, and welcome to today's webinar, Overview of Removals from School, including Manifestation Determination Review, co-sponsored by Peak Parent Center and the Colorado Department of Ed. My name is Pam Christie, and I'll be the room host and monitoring the chat throughout this training. And before we get started, I just want to go over a few things on how you can participate. You'll be muted for most of the presentation, so please use the chat to ask questions. Bill will give some breaks, and that's when I can ask those questions on your behalf. And closed captioning is available at the bottom of your screen. It's my pleasure to introduce our presenter, Bill Brown from the Colorado Department of Ed.
Hello.
Take it away, Bill.
Welcome. Hello and welcome. I am a school social worker by training. I am the affective needs serious emotional disability specialist for the Colorado Department of Education. It's kind of a big, long title. My affective needs part kind of speaks to helping students with emotional disabilities, and I get to do a little bit of work in that general education realm through your PBIS or positive behavior intervention supports to be proactive and preventative. And then the SED part is serious emotional disability, which is kind of the special education hat. So I get to work a little bit in general education and a little bit in special education. And I love questions. So please feel free to reach out with your questions with that. And I appreciate that Pam's going to monitor that chat, and then she can interrupt me because sometimes I don't always see them when they come through the chat. So this particular webinar, we're going to talk about understanding schools' removal process for students, and we're also talking about the manifestation determination review process with that. And so what we're going to look at is what is a manifestation determination review, when does it come into place, and what is parents' role, or how do they participate in that? And then we're going to give you some information on those informal removals that'll count towards that manifestation determination review process. So by the end of this, I hope that you understand what that manifestation determination review process looks like with that, and that you understand what constitutes an informal removal. So we're going to start by looking at two different concepts. So when you have students that are having lots of behavioral problems or challenges with that, and that challenges kind of ends up in them missing school, either through absences or through disciplinary action, we can approach this problem from one of two different perspectives. You can look at it from a disciplinary removal perspective, and that's really what we're going to talk about today. Or you could look at it through a traditional IEP meeting, where we're going to look at placement for the student. If you go with the traditional IEP meeting, then what you're really kind of talking about or looking at is the student appropriately placed in the school that they're at, or do they need to have a different or alternative placement, or even in the context of that placement, they call it LRE, which is the amount of time that they spend in general education versus special education with that. And they have three categories for your LRE. They're in general education 80% of the time and special ed 20%, or they're in general education or special education 40 to 79% of the time, and then general education the opposite of that, or they're in special education more 60%, and they're in general education 40% or less. So you've got your 80%, you've got your 40 to 79, and you've got your less than 40%. So if you're looking at it from that perspective, then you're going to be looking at having a more traditional IEP meeting, where the IEP team is going to make decisions about what is the best placement for the student. The other thing that we're going to take a look at today is those disciplinary removals. So with that disciplinary removals, we're going to talk about manifestation determination review, which is MDR. The purpose of that manifestation determination review is to determine if a student's conduct was a manifestation of their disability or a result of the failure to implement a student's IEP. The reason this is important is if you look at the IDEA, which is Individual with Disabilities Educational Act, with that, what they're really looking at is we don't want to punish students for their disability, for behaviors that are related to their disability. And so that's why this kind of meeting process is put in place with that. So when a decision is made to affect a disciplinary placement in a school for a student with a disability who has violated that code of conduct, the school or agency must conduct a manifestation meeting, and it's around a 10-day time period with that. So students can be removed, all students can remove, general education, special education, 504, can all be removed in for 10 of those particular school days with that. And so when they count that 10 school days, there's two different ways you can count it. You can count it as if it's a 10 consecutive day, meaning they got one large suspension for a large time, or a series of removal that constitutes a pattern over time with that. And so you could look at, and their pattern of time is one school year, and every school year this time frame resets itself. So over the course of the school year, if they had like a 2-day suspension and a 3-day suspension and another 3-day suspension and then a 2-day suspension, when those add up to that 10, that's when you're looking at having to do that manifestation determination process. There is this little caveat kind of in the regulations that says that you're looking at a pattern of behavior over time. And what that's kind of about is if the behavior has a similar purpose with that, if it has a similar purpose with that, then they can be all considered to be related. If the behaviors are dramatically different, then you could count it as two separate patterns of behavior. However, universally speaking, most schools don't try to define out that pattern of behavior, but they can if they want to go in that direction. And I love that we have a question on in-school suspension or out-of-school suspension. I'm going to get to that.
Perfect. Thank you.
Mm-hmm. So in the legislation or in the law, the only time that you're required to do a functional behavior assessment is with that manifestation determination review process with that. So if they have not had one before and you're in that manifestation review process, your school might ask permission to do a functional behavior assessment with that. And our first webinar talked about the functional behavior assessment and what does that mean and what does that look like. And schools always have to have parent permission in order to do a functional behavior assessment. But this is when it is required by law. It is best practice to do a functional behavior assessment when you see a pattern of behavior, but the law states that you have to do it with the manifestation determination review process. So those first 10 days of removal are the same as they are for general education students. And removal means that the parents do not have a choice with that. So that's when it becomes a school-based or disciplinary process, is if the parents feel like they have no choice in that particular removal, where they're called to come and get their student, or they get that formal kind of suspension letter for that. And after that 10-day time of removal, they must hold this particular meeting with that. Parents must get a reasonable notice. The regulations don't define what is reasonable notice. The general kind of acceptable time frame is about 3 days, but each school might have a different timeline based on that, because the regulations don't specify what that timeline is. So it is best practice to start that manifestation determination at 5 days. However, most schools choose to start it at that 10-day time period. The reason it's best practice to start at a 5-day time period is if you've had students who's already been removed for 5 days, and I'm looking at like another 5-day suspension. If I started at 5 days, that gives me time to give the parent notice and have that manifestation determination meeting with that. Because if I remove that student after that 10-day time period, and then the manifestation turns out that it's part of the student's disability, then they have to put in some kind of compensatory services that go in that direction with that. We're going to talk a little bit more about what that means as well. If a student has been suspended for 10 days, yet can a school start expulsion process without an MDR? They cannot if they have a 504 or they have an IEP, an individual education plan. In order for them to go to expulsion, they have to go through the manifestation determination review process first. If they're a general education student and they do not have that 504 or their IEP, then they do not have to go through the manifestation determination review. So it depends on whether they have that IEP or 504. Who needs to participate in a manifestation determination review meeting? This would be your local education agency or your school administration need to participate in that. Your parents need to be participating in that. And then relevant members of the IEP team. So the entire IEP team does not need to participate in the manifestation determination review meeting, but relevant members. So depending on what the infraction is, it may be a mental health person, or it may be an affective needs specialist that might be relevant to have in that particular meeting. So when we talk about that participation, the school administration can suggest who they think is important from that IEP team and invite them. But the parents can also suggest or recommend to the school who they think from the IEP team is going to be relevant or important to attend that particular meeting. With that, in a regular IEP meeting, the general education teacher is required to be there. In a manifestation determination review meeting, a general education teacher does not have to be there. However, if it is that general education teacher who has the best information, or that's where the incident happened, it would be considered best practice to have that general education teacher there to share their side or participating with that. Part of the reason that you're going to give parents that 3-day notice is parents can also bring to that manifestation determination meeting an advocate or a therapist or an outside behavioral person to that manifestation. And so parents need to be given time to get those people on the schedule so they can come in and participate in that meeting. When we have a manifestation determination review meeting, there are 2 questions that need to be asked in the context of that meeting. The 2 questions that need to be asked are, was the conduct caused by, or did it have a direct and substantial relationship to the student's disability? And if it's determined that the behavior is related to the student's disability, then they're not going to apply that general education student discipline system to them. The other question that they're going to ask is, was the conduct the direct result of the district's failure to implement the IEP? With this question, what they're really trying to get at or look at is, let's say, just for example, they were supposed to meet with the school social worker twice a week for emotional regulation skills, and the school social worker was out sick and they didn't have that services provided. And as a result of them not having that time with the social worker, this behavior happened with that. So when they look at this, they're not looking at necessarily the broad implication of that IEP. They're looking at, was there an aspect of it that didn't get implemented that resulted in this behavior happening or taking place? So these are the 2 questions that the manifestation determination review is intending to ask. Questions that sometimes get asked but are not part of the manifestation determination review process is, does the student know the difference between right or wrong, or was the behavior a choice-based situation? And the reason these questions are not great for your manifestation determination review process is that the student may know right from wrong, but if they have an emotional disability and that emotional disability is driving their behavior and that emotion results in that impulsive response, it could be that they engage in this behavior and it's from that emotional content and it's still part of their disability, even though they do know right from wrong. What was it a choice-based? Choice-based meanings, yeah, I knew all the consequences, but I decided to do that anyway. Again, we're looking at that. Is there an emotional component to that? If the school looks at a behavior and they can say it was planned or calculated with that, a lot of times if it ends up in a court of law, if they can prove that it was planned or calculated, that is typically not considered to be part of that manifestation because they're looking for that impulsivity or that emotional context with that. So when we look at IEP, different people qualify for different IEPs in different areas. There's actually 13 different areas you can qualify for an IEP. You can qualify under autism spectrum disorder or specific learning disability, other health impaired, serious emotional disability. Once a student qualifies for an IEP, then IEPs are what we consider need-based, meaning anything that's preventing the student from accessing their general education environment can be identified as a need and can put services in place. The reason I bring this up is sometimes I get the question is that manifestation termination review only for students who have a serious emotional disability IEP? And the answer would be no. Manifestation determination reviews for any student on an IEP, regardless of what area they've been identified in those 13 areas of classification. Because you could have a student that's identified under a specific learning disability or SLD, and if they have a functional behavior assessment and a behavior plan, then you would still go to that manifestation determination review process, because IEPs, once we've had that identification, are then services are set up based on their needs. Anybody have any questions about that?
I don't see any questions in the chat, Bill.
Okay. So if the behavior is a manifestation, meaning it is part of their disability, then typically what has to happen is they have to conduct a functional behavior assessment and implement a behavior intervention plan. However, if a student already has a functional behavior assessment and they already have a behavior intervention plan, then they just need to review the existing one. What they're looking at is the current functional behavior assessment and behavior intervention plan still appropriate for the student? Because if they've had 10 days of removal, then maybe the behavior program is not changing or shifting the behavior like it needs to, and it might need to be readdressed or readjusted with that. And so if it is that manifestation, they're going to either conduct or review that FBA, and then the student needs to be put back into the environment from which they were removed, with the exception of a few special circumstances. Your special circumstances are what they call a 45-day placement. And this happens in an alternative facility. And usually that 45-day placement is so they can diagnose or examine or really kind of dive into what might be driving some of this behavior. But they're only looking at that 45-day placement if drugs were involved, a weapon was involved, or there was seriously bodily injury involved. On my next slide, I define what seriously bodily injury is, because sometimes that gets a little gray. Sometimes school staff might think, oh, I got bit, that's seriously bodily injury. That is not, according to the regulations, seriously bodily injury. The term seriously bodily injury involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss of impairment or function of a bodily member, organ, or mental function with that. So, what is an example of an alternative facility? That is a great question. So an alternative facility might mean they move for that 45-day placement. They may move them from a traditional school where you have your special education services to a school that's called a center-based school. And that center-based school might have a specialized staff that are trained to deal with that particular behavior, or they might move them to a facility school. A facility school is where they kind of have a hybrid between part of it is educational in nature and part of it might be mental health in nature. With that, or some other type of specialty in nature. So it borders on having a day therapy combined with an educational environment, and that would be a facility school. A center-based school would just be, each district sometimes might have a center-based school for elementary, middle school, or high school. And so they might say, if your student needs this level of care, they have to go to this specific location to receive that particular care. And districts are allowed to do that. And so they might put them in that center-based program for that 45-day period, and then they might decide to extend their stay there or return them back to the school, depending on what that looked like. Is there any difference in between the MDR process for IEPs versus 504s? There's not. The MDR process is exactly the same, whether it is a 504 or an IEP. If the behavior is not a manifestation, school personnel may apply relevant disciplinary procedures in the same scope or manner that they would apply to children without disabilities with that. So when they have that manifestation, meaning if the outcome is, no, this is not part of their disability, then they can apply whatever discipline procedures they would to normal general education students, which means if they were out for 10 days and we had this meeting and then they were determined not to be part of their disability, they could be out of school for another 3 days or another 5 days if it's not part of their disability with that. If it is part of their disability, then they have to figure out how to work with the student in the context of the school, which is why they do the FBA and the behavior intervention plan, so that we can work with them in that school environment. Compensatory services, this might be an example, or this would be if we were at our 10 days and they had 10 days removal, and we put the student out for another 3 days, because it took us 3 days to get the parents together and to schedule a manifestation determination review meeting. We had that manifestation determination review meeting, and it was determined that the student's behavior was part of their disability. Now the school is obligated to make up the services that they missed for those 3 days that they were out, and that would be your compensatory services. And so they're going to have to go back and say, how are we going to give them make up missed IEP services? So that means the next week, maybe I might have to meet with providers for a longer period of time. I got to spread that out with that, but it's a plan to say, how are we going to make up the time that was lost because we sent them home and they shouldn't have been sent home because of that disability. Different schools have different processes for doing that. The important part is if they do send them out past that 10-day and it is part of disability, the school has to make up that educational time that was lost. Lack of unity in decision making. This happens probably more often than people might think, that we get to a manifestation determination review process and the school staff are split, or school staff versus parent or split. And so when you're talking about the manifestation determination, it's nice if you've got consensus that everybody's going in the same direction. But if there is not consensus and there is a split in that, the LRE or the school administrators get to make that final decision, and parents cannot override that final decision. Parents can file a dissenting opinion saying, I disagree with the decision they're making, but they can't overturn, but they can sure fill out the paperwork that says, I disagree with this decision. All right, here's that question that got asked in the chat. Is in-school suspension counted that towards that 10-day time period? The answer is, it depends with that. If your in-school suspension program provides the student with access to the general education curriculum, and they continue to receive their IEP services, and they get to participate with non-disabled students, if all three of these criteria are met, then in-school suspension does not count towards that 10-day time period. If any one of these is missing, then in-school suspension does count towards that 10-day time period. So you're going to have to look at that in-school suspension program. If in-school suspension is a study hall where they're just given work to do, it's going to count towards that 10-day time period. If in-school suspension is just community service, it's going to count towards that 10-day time period. But if they have access to general education curriculum, if their IEP services are provided, and they're in a room with non-disabled students, then that does not count towards that 10-day time period. So it depends on how your in-school suspension is set up as to whether it does or does not count. Bus suspensions. This is another it depends question, or another gray area. If transportation is listed on their IEP as a related service, and they get suspended from the bus, not suspended from school, but for suspended from the bus, those suspension days count towards that 10-day removal time if transportation is a related service. If transportation is not a related service, then it's a little gray. If the bus is the only way the student has to get to school, and they don't attend school because they've been suspended from the bus, it could count towards those 10 days. That decision wouldn't be made until you ended up in a legal or court situation, or you went for dispute resolution through the Colorado Department of Education. They would take that on a case-by-case basis to make that determination if a bus suspension does or does not count. So what we communicate to school staff is, if you're writing a behavior intervention plan, you need to make sure you include the bus as an environment for that behavior intervention plan, and you need to train the bus teacher on the implementation of that behavior intervention plan, so that they can be proactive, and that your bus department and your school department need to communicate to each other around those suspensions, because if it might impact your manifestation termination review process. Half days or shortened schedules. This is also another it depends question. If the shortened days or half day schedules, if that changes their placement, for example, if they are supposed to be in general education 80% of the time, and special education 20% of the time, and we shorten their day, and so now they don't have access to that general education 80% of the time, that might be considered a change in placement with that. And then if it is a change in placement, we got to go back to that concept of, is it a disciplinary removal or is it an IEP team decision? If the IEP team, which the parents are a part of, decides to shorten that school day for that particular student, then that does not count towards that 10-day time period. If it's made at a student discipline level, that for behavior that you're not allowed to attend longer than X number of time or half days, then that counts towards that 10-day time period. Regardless of which way they go, whether it's a student discipline or IEP, if you're going to shorten a student's day, they really should have, and this is best practice, this is not regulations, they should have a plan that says, how are we going to move the student from a shortened or half day to full days? They should have a plan that builds that in place. What happens if an MDR did not occur prior to schools starting expulsion proceedings? Is there a difference in MER in regular public versus public charter schools? The MDR manifestation termination review it's the same whether it's a public school or a charter school. It is the same process. A lot of times, and this is a generalization, some charter schools aren't set up to provide the level of IEP services that might be needed for a student, because a lot of times they don't have access to maybe OTs, PTs, or speech, or those specialized people. So a lot of times, in order to get those services, they're going to have to go to a public school versus the charter school if they want those particular services. But the MDR process will be the same, whether it's a charter school or a public school with that. If the MDR did not happen prior to an expulsionary hearing, and they do have an IEP or do have a 504, this would be an area where you might look at filing a dispute resolution with the Colorado Department of Education. The Colorado Department of Education has multiple routes. You can do mediation, you can do dispute resolution with that. And so then what that happens with that process is then a mediator or lawyers get involved in that process. CDE has a lawyer group that looks at these different pieces, and what they would do is they would determine whether the school did the right thing or didn't do the right thing with that. And the school didn't do the right thing, meaning they expelled the student without having that process done or completed, then the school might have to reevaluate or go back and provide compensatory services. The outcome of that would be decided through that process by the lawyers who are kind of involved in that process with it. So I don't have a black and white answer for that, but you can look at filing a dispute if that is a concern that happened and they didn't follow that particular process. threat assessment teams. There have been times when a threat assessment team has said, oh, a student is dangerous or unsafe and therefore they can't come to school. And until we get confirmation that they're no longer safe, then they can't return. If the student has an IEP or 504, a threat assessment team cannot override an IEP team. An IEP team has to make that final decision as to whether or not they are removed from that information. So we're going to move on to informal removals. But before I do, does anybody have any questions about the manifestation termination review process? And if it's easier, you can just unmute and ask your question, and then we'll talk about informal removals. All right, doesn't sound like we have questions, so I'm going to move on to the informal removals. So with informal removals, an informal removal, it might be anytime that the school calls a parent and say, if you come and pick up your child, and we won't suspend them with that. That would be considered an informal removal from that. Your informal removals do count towards your 10-day piece for your manifestation termination. Where this kind of gets a little hard or a little bit difficult is schools have tracking systems where they track all those official suspensions or those removals. And so they can go back and give you exact data on that. Most schools do not have a system to track informal removals with that. Fortunately, a lot of your special education staff are good at tracking these informal removals. Your case manager or your mental health a lot of times will track these informal removal processes, and they'll have conversations with school administration with that. So what is an informal removal? This is just some examples of what that informal removal is. Schools might call the parent to pick up the student every day early or most days, or they say that you can't return back to school due to behavior, but it's not, they don't call it a suspension. Or a school sends home a student for violating a policy, but don't label it as a suspension. They require long-term use of shortened school days with that, or sending frequently in the middle of the school day. So if the parent perceives they don't have a choice but to pick their student up, that counts as that informal removal. Is a suspension letter required to be provided to be counted as a formal suspension? That is a great question. I don't know 100% the answer. From my experience, yes, they need to have a suspension letter. The reason that's a gray area is Colorado is what they call a local control state. And because it's a local control state, every school, every district, every administrative unit or BOCES gets to interpret the state and federal regulations on their own, and they get to write their own policies and procedures to meet those regulations with it. So because of that local control, it might be that one school says they can be suspended with a verbal notice rather than a letter coming home, or they could be suspended with an email letting you know with that. And so you'd have to know your local policies and procedures to know with that. In my experience working in schools, there was always a letter if it was formal, but you'd really need to look at your local policies and procedures to determine whether that is a requirement or not a requirement. Other types of removals might be placing the student on homebound instruction, or telling them that remote is their only option with that, or they can't come back until there's a particular staff person that is available with that. And so there's different things. Another place that sometimes schools things get out of miscommunicated is sometimes they put in level systems for behavior programs. And if those level systems restrict their access to general education environments, so the student has to earn their way in, that would be a type of informal removal, because students shouldn't have to earn their way into general education. with that. So level systems should be set up on maybe a level of independence or level of supervision, but they should not restrict access to the general education environment. So there are lots of different informal removals with that. And all these informal removals are going to count towards that 10-day process with it. So it's important to just kind of know that or be aware of that. How about daily early bus loading, students that are in wheelchairs being taken out the bus 15 minutes? Okay, that is a great question with that. And so we need to make a differentiation here. If for their IEP services, we decide that 15 minutes going out early is important to get the student on the bus so we're not fighting crowds and we're not fighting stress on that, then that doesn't count towards your manifestation determination review process. And so it's looking at the difference between if an IEP team decided this versus it's a administrative school discipline piece with that. Same with the informal removals. If I go back to homebound or virtual instruction, if a parent says, you know what, my student really learns better virtually, and they meet with the IEP team, and the IEP team says, we're going to set the student up virtually because that's what's best for them and in their best interest, that does not count towards that 10-day removal period. So you really got to keep in this differentiation. Is it the IEP team making its decision about what's in the best interest of the student? Same as if an IEP team said, I'm going to shorten their school day, and that's what's best for the student because they have ABA therapy in the morning, and then we're going to put them in school in the afternoon. If the IEP team makes the decision, then it does not count towards the manifestation. It only counts if it is a school administration decision around discipline where the parents don't have a choice. That's when it counts towards that 10-day process. So great question. Thank you for asking that question. So IDEA, one of the purposes are the individual with individual disabilities educational act. The key purposes with that is to provide services so that children with disabilities can stay in school and learn. Federal law requires that children with disabilities who require behavioral services receive them, that they receive them at the same education as other students, and that they are educated with peers to the maximum extent possible with like peers. Under IDEA, that individual education or IEP team must consider a number of special factors when developing, renewing, or revising a child's IEP. IDEA specifically requires IEP teams to consider the use of positive behavior interventions and supports and other strategies to address behavior for any child with a disability whose behavior impedes his or her learning or that of the learning of others. So really, this manifestation determination review process is about protecting these IEP rights or that free and public school rights. For Section 504, Section 504 requires non-discrimination under the federal grants and programs. This section of the Rehabilitation Act of 1973 ensures that no otherwise qualified individual with a disability in the United States shall solely by reason, shall otherwise be, sorry, I transitioned to the wrong sentence. I apologize. Solely by reason of his or her disability be excluded from participating in, being denied the benefits of, or being subjected to discrimination under any program or activity receiving federal financial assistance, and that schools receive federal financial assistance with that. And so with that, I just have time for questions with that. So I am going to stop sharing my screen so that I can see everybody's faces. So if you want to turn your camera on, unmute, feel free to ask questions. It can be about the manifestation determination review process. It could be about informal removals. It could be about a functional behavior assessment or behavior intervention plan that we covered last time as well. I will do my best to answer whatever questions you might have. Or you can still put them in the chat. That's okay too.
Are students with an IEP or a 504, like, are they able at any point to be expelled from a school? And like, what does that look like? How do we get there?
Okay. Yes, they can be expelled from a school. So that would be, I'm just going to throw out a wild example for you. Maybe they have a specific learning disability where the IEP is all around math and math behaviors with that. And they start having maybe stealing behaviors, and they've determined that that stealing behaviors has nothing to do with their disability in that particular area. So once they have that 10-day removals, they would still need to do an FBA and a BIP with that manifestation determination review process. But if they determine that that stealing behavior is not part of the disability, then they could be suspended. And every time after that you have an incident, you have to have another manifestation. So it's not a one and done. It's with each individual incident you have that manifestation of termination. If you have a number of those, the school might decide we're going to go to an expulsion hearing with that. And if they go to that expulsion hearing, then again, they have to determine, is this behavior related to the student's disability or not to the disability? If the student behavior is not related to the disability, then they can suspend that particular student or expel that particular student and move them out of schools. If you have an IEP student who is expelled under that condition or that situation, they usually have to do an alternative IEP plan that's going to spell out or say, during the time that they're expelled, this is how we're going to provide those IEP services. With that, it might be through a home tutor, it might be through a school person coming out to the house, or it might be that the parent brings the student into the school for their IEP services and then takes them back home with that. So they can be expelled. And if they do, they should have an interim plan that says how they're going to meet the service on the IEP with that. If it's part of their disability, then no, they cannot be expelled for that. So it really determines the outcome of the manifestation termination review.
Okay.
Anybody else, PM, or want to add to that information or share more information? Feel free to jump in if I missed something. Is that helpful?
It is. Yeah. If you can't tell, a lot of my questions are very specific because I have just undergone a bunch of the questions that I'm asking you. So this is very helpful. I appreciate it.
And the goal behind these webinars is to really empower parents and to educate parents so that you can speak to these problems with the school, and you know what your rights are, and you know what actions you can take going in that direction. So if you ask me a specific question about your child, I'll probably be evasive because I'm not allowed to do what they call child-specific consultation. But I'm more than happy to answer any process questions so that you can be as knowledgeable as possible to help you interact with the school and collaboratively so that problem solving can take place, because this is hard stuff. This is really hard stuff.
Yeah, it's been, the last month has been rough, but we're getting there.
Okay.
But anyways, no, this is really helpful. So I appreciate it. Thank you.
Okay. And if you have questions later, you can email me or call me and I'll do my best to answer those questions. We also have a parent specialist at CDE. I'm the specialist for serious emotional disability, but if I can't answer your question, I can probably find somebody else who can.
Sorry, another one just popped in my head. So is there like a specific list of diagnoses under serious emotional disability that like qualify, or like how broad is it, I suppose? Because my son qualifies because he has ADHD, so like he's eligible with that, but he also has other diagnoses. And so I'm just wondering if they can be included as well.
That is a great question. Schools don't operate on diagnoses per se. So in the outside the school world, and I worked in the clinical world for 12 years prior to coming into the school system, you have to be able to diagnose somebody in order to provide treatment or services. So when you're talking about ADHD, you're talking about oppositional defiant, or you're talking about mood regulation disorder, those are going to come outside of that school environment. In the school environment, they can use those diagnoses to help inform what IEP area they might qualify under. But what they're really looking at is, do they have a disability? And the diagnosis can help with that, but a diagnosis is not required to determine whether there's a disability. And then the other part of that is, does that disability impact their ability to access general education with that? And if it is, they need specialized instruction with that. So when you're talking about diagnosis versus IEP categories, there's not a correlation per se or a direct that these diagnoses equal serious emotional disability.
Okay.
Generally speaking, when you're talking about ADHD or attention deficit hyperactivity disorder or attention deficit hyperactivity, with that, that sometimes falls under what they call other health impaired, rather than falling under serious emotional disability. A lot of times what tends to fall under serious emotional disability might be anxiety, might be depression, it might be trauma, and those different areas. It just really depends on the wide scope of those different diagnoses, but it's not the IEP process is not diagnosis driven.
Okay.
Is that helpful?
It is helpful. Yeah. I mean, yeah, it's helpful.
Okay.
So I do have a quick question. What if your child has had behavioral incidents and you have taken them out? Does that, like, that doesn't count towards the 10 days?
Correct. If it's the parent's choice to take them out and remove them, it does not count towards that 10 days. Sometimes parents will say, I know my child, and I know if I leave them at school, it's just going to deteriorate. And so I, as a parent, am making the decision and I'm going to remove them. That's okay. The parent can do that. And that does not count towards that 10-day process because that was the parent's choice, not the school's choice.
Right. And then the other question I had, and you kind of answered it, but if they do get expelled or suspended, and it was not a result of the disability, do they have to provide education in an alternative setting, or is that just it? If they get expelled, they get expelled.
Usually they provide some type of alternative education with that. So I'll just use an IEP example. If they get 3 hours of reading a day, if they're expelled, they may get 1 hour, 1 or 2 hours a week rather than 3 hours a day with that. So they're going to change or adjust the level of services they get. And they usually do it through tutoring services. And so a lot of your student discipline systems in schools have tutors that they hire, and these students that are expelled will then get a tutor. Sometimes if it's not a tutor, it might be online learning, where we're going to provide them an online platform, and then they might get it through Zoom services. So it could be tutor, it could be online. Sometimes it might be you have to go to this special school or place to get these services, and they're going to be provided at a different location. So there's a variety of different ways to approach that, but they need to, if they have an IEP, they need to provide some type of services related to that IEP. They can't simply tell you get nothing. If it's a general education student, they will get nothing. But if it's a special education student, they're going to need to have some kind of IEP services provided during that.
And 504 students as well.
And 504, correct. For 504 or for IEP, they're going to need to have some type of services. And the difference between a 504 and an IEP is a 504 requires what they call specialized instruction, meaning I need some kind of education in some area with that. A 504 has no specialized instruction. It is accommodations and modifications only with that. So with the 504, you still go through the manifestation determination review process, but because there's no specialized instruction, the services during the expulsion might be different because you're not being provided that type of instruction under a 504. And I'm not a 504 expert, so I don't know exactly what that looks like.
Thank you.
Mm-hmm.
If a student is expelled, who retains responsibility for providing the education? Still the school that expelled them?
That is a great question. And sometimes the answer is not always black and white. Normally, it's whatever school expelled them is responsible for providing those services that are provided to them. Here just recently, I had a case came to the Colorado Department of Education where it was a K-8 school, and they suspended an 8th grader. And since this school doesn't provide services beyond 8th grade, 9th, 10th, or 11th, and this was a charter school situation, they would go back to their home school, and the home school is responsible for schooling them. So in that particular specific situation, because they were K-8 and they got suspended in 8th and they would come back in 9th, then the responsibility comes back to the home school to provide those services. But typically it is the school that is suspending them that's responsible for that, unless you've got some kind of odd nuance in there. That hopefully is helpful, but maybe doesn't 100% answer your question.
No, it did. Sorry, I was just kind of thinking some more.
No problem. This is hard, difficult stuff to take in and process and wrap your head around. And my guess is you might have more questions 2 days from now than you do now, because you're just trying to process all the information that I shared.
Any other questions? You guys are really doing a great job with asking good questions.
I love all the questions. Thank you.
Bill, did you want to put your last slide up just one more time
Sure.
if people wanted to contact you? And on behalf of Peak Parent Center and the Colorado Department of Education, we really appreciate you being on this webinar today. You will receive a training evaluation after this presentation, and we'd appreciate if you would just take a minute to complete that to provide your feedback as we strive to make improvements here at Peak Parent Center. We will post this recording to our website by next week under recorded webinars. And thank you, Bill, so much. We appreciate your time and expertise on this hard topic. And if you have any questions, you can contact Bill Brown here or any parent advisor here at Peak Parent Center. Our website is www.peakparent.org. Our number is 719-531-9400. And our email address is parentadvisor@peakparent.org. Please check our website to register for our upcoming trainings, webinars, and events. And with that, I thank you so much for joining us and have a great day.